If you're an employer or an employee, you need to understand the obligations and entitlement in relation to a written statement of employment, a written statement of terms of employment. That's what I'm going to cover in this video after this. Okay, the Terms of Employment Information Act of 1994 obliges the employer to give a written statement of certain terms and conditions of employment to the employee within 2 months of starting the job. This written statement would typically be a contract of employment or called a contract of employment, but it can also just be simply a statement of certain terms pursuant to Section 3 of the Terms of Employment Information Act of 1994. This will set out basic information like the name of the employer, the name of the employee, when the employment started, what is the situation in relation to rest breaks, what is the situation in relation to sick leave or absences due to sickness, is there a pension in the workplace, is there a retirement age, and so on. Section 3 of the Act sets out the obligations. If the employer does not give a written statement to the employee within 2 months of starting, then the employee can bring a claim to the Workplace Relations Commission, and this claim can lead to the adjudicator awarding up to 4 weeks remuneration to the employee. So it's a very, very straightforward claim, and it's a very, very straightforward case to decide, because clearly the statement, the contract, the written statement has either been given to the employee or it hasn't. And if it hasn't, well then the employee is simply going to win that case. Now, there are certain exemptions, certain basic exemptions. If an employee, for example, is working less than 8 hours per week, or is in employment or has been employed for, I think, less than 1 month, then there is no entitlement or no obligation to a written statement. But by and large, that is the position. Up to 2 months, the remuneration can be awarded to the employee for the employer's failure. Even if the employee is in the job for a very, very long time and is in the job since before the commencement of the legislation in 1994, the employee can still ask the employer for a statement, and the employer then has the obligation to provide it within 2 months of that request. And the situation in relation to claims being brought to the WRC is that if an employee is bringing a claim against an employer to the Workplace Relations Commission, then this is a very, very simple claim that's likely to be thrown in along with the substantive claim. For example, an employee may be bringing a claim for not getting rest breaks, or for unfair dismissal, or for bullying or harassment in the workplace. But certainly, whether he wins or loses, or she wins or loses those claims, the question of a statement of written terms is very, very straightforward. I hope you find this video useful. If you do, you might give us a thumbs up down below. If you're an employer and you need a contract of employment, I can provide you with a template, or I can draft individual contracts for each of your employees. It's up to yourself. But if you find the video useful, you might give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. I'm Gorry, I'm a solicitor in Enfield.